our webinar. We are going to be talking today about the updates and changes in the law that have come out as a result of the Family First Coronavirus Response Act. Specifically, we're going to be talking today, I'm going to be talking today about the FMLA portions of that new law, and then I'll let Tyson and Brett, I guess, introduce what they're going to be talking about. So let's go ahead and go to the next slide. The Congress moved, enacted, and was signed into law the Emergency Family Medical Leave Expansion Act. And the act is was set to take place no later than 15 days after the date of the enactment of the act. The DOL announced on the 24th that the act would take place or took effect on April 1st. It's important to note that this act applies to all employers with less than 500 employees. Okay, next slide. Go to the next slide. There you go. Under the act, first question is, who's an eligible employee? So an eligible employee is entitled to 12 work weeks of leave during any 12-month period for one or more of the following reasons. And the act added point F, which is you're eligible during the period beginning on the date of the Emergency Family Medical Leave Expansion Act, so beginning on April 1st and ending on December 31st, 2020, because of a qualifying need related to a public health emergency in accordance with Section 110. And this is Section 102A, 1F of the Act. So the questions come into play: what's an eligible employee? What do they get? What benefits do they get? Who's an eligible employer under that? What's a qualifying need? So we're going to address some of these questions right now. So go ahead to the next slide. So what employers are covered first? For you, we're wondering, are we covered or not? So the act applies to all employers with less than 500 employees. Now, I know you're asking yourself, well, are there exceptions to this? Because that's a huge number, and the normal FMLA without this applies to employers that have over 50 employees within a 75-mile radius. This is quite a change from that. So there are some small exceptions, but they're not probably the exceptions we're hoping for. The first main exception isn't an exception to the act itself, but an exception to part of it being applicable to you. An employer with fewer than 25 employees is not required to restore employees to their prior position under certain circumstances. So you're aware that under the FMLA, if an employee takes FMLA leave, it's protected. When they return to work, you need to put them back into their prior position, or a position that is reasonably equivalent or substantially equivalent position to the one they left. This act exempts you if you have less than 25 employees from that duty, but only under very limited circumstances. First circumstance is this: the employee has to have taken leave under the FMLA Act. So under this new act, they have to take leave under that. The next is the position held by the employee when they have left has to no longer exist due to the economic conditions or changes in operating conditions that affect employment and were caused by the COVID-19 crisis. So your employee takes leave under this new act. While they're gone, their position no longer exists, and it doesn't exist as a result of the crisis caused by COVID. Third, you have to make reasonable efforts to restore the employee to an equivalent position with equivalent benefits and pay, other terms and conditions in employment. And if you couldn't restore them, that wasn't possible, then during the following year, you'll have to try and contact the employee if an equivalent position becomes available during that year period. And that year period starts on the date the qualifying leave ends, or 12 weeks after the employee started taking leave, whichever is soon. So basically, you don't have to restore them to their current position under very limited circumstances, and your duty to try and restore them to a position, and a substantially equivalent position, continues for a period of 1 year after they return to work, where they leave. So that's not the greatest exception. It does put quite a burden on your employees. Next, healthcare providers and emergency responders may elect to exempt themselves from the act. So they're not automatically exempted from it, but they can elect to exempt themselves from the law. I'll go ahead to the next slide.
Matt, is there an ability for you to get closer to your microphone?
Yeah, are people not hearing me very well?
Yeah, it's a little garbled. So if you can get closer to your microphone, that would be better.
I don't. Does that help any?
Yeah, I think that's better. Thank you.
Okay. Okay, so let's go. There we are. At the next slide. So those are really the only exceptions that are in the statute itself, as far as applicability goes. So then the question is, who's an eligible employee? Any employee who's been employed for at least 30 calendar days is an eligible employee. So what does that mean? Well, it means that they've been on your payroll for 30 days. It also includes any temporary employee who worked for the employer, I should say employer, if the employee was later hired by the employer. So if you have somebody who was a temp or through an agency, and you recently hired them, and they were working at your facility for about for more than 30 days, and you just barely hired them, they're still going to be considered an eligible employee. Now, there's a potential litigation alert that I want to point out to you. If you have misclassified workers, in other words, if you have somebody who is classified as 1099, but they really should be classified as a W-2 employee, this is a potential risk for litigation, potential class action litigation if you have a lot of them. Anyone who is supposed to be classified as an employee has rights under this statute. So we need to be sure that our classifications are correct. So you want to go through and double check to make sure that your classifications of independent contractor versus employee are correct. Otherwise, you're leaving yourself open for potential litigation for benefits under this new FMLA Act. Now, what about notice from the eligible employee? Notice isn't really required under this act, and the reason is because it's only required if the need for leave is foreseeable. Well, the whole purpose of this act really is to provide leave in this emergency situation where it's really not foreseeable. But even if it is foreseeable, you only need to provide notice as is practicable. You're not required to give 30 days notice or anything like that. So if it's foreseeable leave, they've got to give you some notice. If it's not really foreseeable leave, then they just got to give you notice as soon as they know. Not much of a benefit for the employer there. Go ahead to the next slide. Go ahead to the next slide.
Just bear with me, Matt. I'm having a technical issue. So.
Okay.
Sorry about this. Just bear with me for a moment. Thank you.
Sure. So I just saw a question pop up that says, is this leave eligible for full-time and part-time employees? There's no distinction under eligible employee for that as far as the act goes. It just says you've got to be employed for 30 days, and that's it. Doesn't make a distinction. It's not like the normal leave, FMLA leave, when you're taking leave under a reason besides Section F. Then you've got to have the 1,280 hours and be employed for at least a year. This is different. This just says the only requirement is you've got to have been employed for 30 days. So unless we get some other clarification from a regulation from the Department of Labor, it appears that this applies to all employees who have been employed for at least 30 calendar days.
was another question about healthcare providers, and asking if you could expand on that.
I don't see the question, but I'll go ahead and see if I can. Maybe it's right here. Yeah, I don't see the queue. Oh, here we go. Maybe this is it. There we go. I can scroll down. So healthcare providers, it doesn't give much. There's no definitions that are in there. So I'm going. So until we get further regulation from the DOL, it's very difficult for us to say who they are. But I think it would be safe to say healthcare providers are going to be your nurses, doctors, nursing facilities, medical facilities, healthcare providers in general, hospitals. I think what they're trying to say is if they want to exempt themselves from this, they're allowed to. Just doesn't make it a requirement that they're exempt. So they're not automatically exempt. So some hospitals may want to provide this leave for people, and others may say, no, we want you to be at work, and we're not going to provide the leave. Without further guidance from the DOL on with regulation, we don't have anything more clear than what's stated in the statute. We are hoping to get that guidance before April 1st when this goes into effect, but it's unknown if that's going to happen or not. Here's a question too. An employee who became ill prior to 4/1 would not be eligible, correct? That's an interesting question. If the employee is still employed after 4/1, then yeah, they're probably going to be eligible for this. But the real issue here isn't, and you're thinking about, we got to talk about the qualifying reason that you get this new leave, and the qualifying reason for this leave is not being sick. The qualifying reason for this leave is something different. We'll talk about that in a second. But if they were sick and they needed to stay home because of an illness, then they may qualify for normal FMLA, which has the other requirements, which would be the 1 year of prior employment, 1,280 hours worked and those requirements. So that would be under the normal FMLA, not under the current FMLA. They also may fall under protections under the Americans with Disabilities Act and providing them with a reasonable accommodation. But that, again, is prior law, not the current law that we're talking about here. So let me look at this other questions here. What if an employee had a specific end date for their work this year, e.g. part-time instructor will only have 4 weeks left in this semester? They entitled to only 4 weeks of leave paid at the 2/3 rate or a full amount of up to 12 weeks? Well, that's a very good question as well. I believe that when you look at the FMLA, employees who would otherwise have lost their employment, regardless of their status as FMLA protection, generally lose their employment the same. For example, if a person is on FMLA leave and then their entire department gets shut down, that person is allowed to be laid off along with the rest of their department. So I would believe that that the same requirement would follow here, where they would only be required to 4 weeks of pay. That's subject to change, obviously, depending on DOL guidance and interpretation. We just have to figure that part out as it comes. The next question here is, what does reasonable verification look like for the EFMLA or for an employee who's unable to work or telework due to their child's school being shut down? I'm hoping that something gets provided to us from the DOL when they issue their guidance. At this point, we don't really know. There are the forms that we have already for our normal FMLA, and I think we could just take those and change them, if you will, to provide us the information that's necessary for this. But I think for the most part, we're really going to know already for a lot of our employees, if our schools are shut down and our employees have healthcare benefits, we're probably going to know if they've got children under the age of 18 who are at home. And I think it won't be too challenging for us to verify that. I'm not sure they're going to require us to get a signature from the principal or from any official. It just seems like it would be a more casual verification. But again, I'm hoping this comes out to us through the DOL's guidance. The next question there is, this leave is paid, correct? And it is partially paid, and I'll talk about that in another slide, but let me go through really quick and, if we can, just talk briefly about what we have here as far as what's a qualifying reason. I think we've already tapped on that a little bit in one of these questions here, what the qualifying reasons are, but I want to just go over that here really quick, and that's on another slide, but as our slides aren't quite working right now, we'll address it here really quick, and then as the slide pop up, we'll see it. So let's see here. The qualifying reason for the FMLA leave is this. The employee is unable to work or telework, which I think is very interesting and important to recognize. That means that the employee can't come into work or cannot work from a home. And here's the kicker. Due to a leave to care for the son or daughter of a healthcare, due to the leave to care for a son or daughter of such employee if the school or place of care has been closed, or the child care provider for such son or daughter is unavailable due to a public emergency. So that's the kicker. If they have a child who's a minor at home and the child's school is closed or their place of care is closed, let's say they go to a daycare facility or babysitter or something like that, and they can't work because they need to care for their son or daughter, then this is available. The question comes into play, and there's a little wiggle room here possibly. If you rearrange their hours, if you move things around so they can work different hours. So let's say normally they would work from 8 until 3 when their kids were at school. And now you let them work from 3 until 8, or you try and move things around. Does that alleviate issues, or does that alleviate? Maybe it does, maybe it doesn't. So it would be good to talk to your employees who are trying to take this leave and ask, is there some way we can accommodate your schedule so that you can still work while still caring for your son or daughter who's at home with you? It might work. You might be able to get somebody who can rearrange your schedule and make that happen. The public health emergency, just so you know, means anything related to COVID-19 as declared by the federal, state, or local authorities. So then the next question, again, it was already brought up. Was it paid or unpaid? And the answer is yes and no. Your first 10 days are unpaid, meaning you don't get FMLA paid. But after that, if you are still on this special FMLA leave, then you will receive no less than 2/3 of the employee's regular rate of pay as determined under the Federal Labor Standards Act. So that's important to recognize. But it is capped, so it's not just an unlimited check. It's capped to $200 a day for a total of $10,000. So there's a cap, and that's beneficial. And again, it's important to recognize, when does it take effect? It takes effect April 1st, which means if employers are considering laying off employees or having work slowdowns or stoppages or furloughs or whatever else you want to call it, you probably want to make those changes before April 1st so that employees aren't able to apply for or request this leave. Because if they apply for this leave and then they are awarded the leave, and then you lay them off, then they can bring a claim of retaliation. You laid me off because I took this leave. which everyone wants to avoid. You don't want to avoid claims of retaliation or bad faith. So I think that's the urge and the urgent need to understand when this starts. It's also the urgent need for us to recognize what our obligations are and what our work requirements are going to be, and really trying to figure out what we can and cannot afford, understanding all the aspects of the law, not just this part, but the other aspects, which Tyson is going to talk about, and also which Brett's going to talk about. I know some of you guys have said, are the slides going to be available? I believe they are. Isn't that right?
Yeah, we can make the slides available after the webinar.
Yeah. Hey, Matt.
Yeah.
Are you there? Can you hear me?
I can, yeah.
I think I have control of your slides somehow. I don't know how, but it looks like I can control them from here. Somehow I've become the host of this session.
Okay,
So
go ahead and move forward then.
I will do my best to keep up.
Tyson,
qualifying need. Yeah, go ahead and go to. Oh yeah, right. You're the host. That's weird. Go ahead to the next one.
To me. Keep going. Next.
Yeah, go to the next one. I'm all finished. We're gonna go all the way to Tyson though.
Okay.
There you go.
Can I interrupt you guys for a minute?
Sure.
Tyson, you can advance the slides, but only you can see the slides advancing. I don't think anyone else can.
I can see what Brett was advancing there.
So unfortunately, and my browser window is frozen up, so I'm struggling to get control of the webinar right now. So
I think from what one of the people just commented in, they can see when Brett's advancing them.
Yeah, they've got it.
Oh.
Yeah, they can see them advancing. So
about 3 minutes ago, a note came up that said I was the host, so I assumed that meant it came to me somehow.
All power has been transferred to Brett, and now I will. That's quite a transition into me. So this is Tyson Horrocks. I'm based out of the Salt Lake City office. Also work in the Nevada office, and I'll advise clients in Arizona. I'm going to be covering the Emergency Paid Sick Leave Act. As Matt discussed earlier, there's a little bit of confusion about when the bill the act would go into effect. The original understanding of pretty much everybody was April 2nd, 2020, until 2 days ago when the Department of Labor came out and said April 1st. And so we are advising everyone to go off the April 1st deadline, since that is what the Department of Labor advised. And the bill will remain in effect until the end of the year, December 31st. Much like the emergency FMLA, this applies to employers with 500 employees or less. Under the Emergency Paid Sick Leave Act, employees will be entitled to up to 80 hours of paid sick leave. And differentiating this from the emergency FMLA, where you had to be employed for 30 days prior to taking your FMLA leave, employees are immediately eligible for paid sick leave, regardless of the length of employment. So you could hire an employee tomorrow and have them take paid sick leave Monday or Saturday, whenever their work days are. So next slide, Brett. So one of the questions we've received from a lot of our clients is, how do we determine whether or not we have 500 employees? Well, under the Paid Sick Leave Act, you will make this analysis at the time when the employee is seeking to take the leave. So your analysis may fluctuate. If you're right around that 500 employee cusp, if you go above or below it, it may depend upon whether your employees are entitled to leave the paid sick leave at that time. When looking at whether or not you hit the 500 employee threshold, you will be looking at full-time and part-time employees within the United States. So not your international employees. You're looking at anyone United States, any of the states, District of Columbia, or any other territory of the United States. In making this calculation, you'll include your employees that are on leave, just like you do with the emergency FMLA, temporary employees who are jointly employed by you and another employer, and day laborers supplied by a temporary agency. But you will not count independent contractors. And as Matt reiterated, this does create a potential risk and liability for employers out there that may be misclassifying independent contractors and W-2 employees. So next slide, Brett. Another common question we get is, we're sister companies or we have some sort of relationship between these companies. How do we determine whether or not we are 50 employees or 750 employees as a conglomerate? And so under this Emergency Paid Sick Leave Act, a corporation is deemed to be its establishment and divisions as a single employer. However, if a corporation has ownership interest in another corporation, the sister company analogy, the two are deemed separate employers unless they are joint employers with respect to certain employees. And that's a very fact-based analysis and would apply the joint employer analysis under both the FMLA and the Fair Labor Standards Act. And so if you have questions about whether or not your employees are joint employees and are part of and your sister corporation's employees should be counted, give one of us a call. We can help you walk through that analysis, make that determination. The 80 hours of paid sick leave qualifies for those that are unable to work or unable to telework. The Department of Labor clarified that the other day for the following reasons. Subject to a federal, state, or local quarantine or isolation order related to COVID-19, advised by a health care provider to self-quarantine due to COVID-19 concerns. So, you've been tested or exposed, but you don't have a positive test, or you're experiencing symptoms and seeking medical diagnosis, caring for an individual that is subject to one of these quarantines, caring for an employee's child if that child's school or place of care is closed or the child's care provider is unavailable due to the local public health emergency, or the catch-all that we have here, which is kind of experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. Brett, you can go to the next slide there. So the question becomes is, the 80 hours, you can apply that for your full-time employees, and they get up to 80 hours. We've had a lot of clients inquiring, what if I have employees that work, 4 10s? Is this 10 days that they get? But it's been made very clear that it's 80 hours. We're going off the hour calculation and not days worked calculation. The one exception to that is part-time employees. And when trying to determine the amount of leave a part-time employee is entitled to, you'll need to look at the average number of hours worked in a 2-week period. Now, that's assuming that your part-time employee works a consistent schedule that you can easily look at and say that employee is a 20-hour per week part-time employee. So under this Emergency Paid Sick Leave Act, they would be entitled to 40 hours over total. However, if the part-time employee's hours are unknown or the part-time employee's schedule varies, then you'll look back 6 months to calculate the average daily hours. So you look at how much they worked over that, divide that by the days worked, try to figure out what the hours are. If your part-time employee has been working for you for less than 6 months, then at that point you would look at what they have been working and what the agreed expectation was that they would be working. Next slide for me, Brett. The employees will be entitled to the regular rate of pay, 100% of the rate of pay, for the first 3 criteria under the Paid Sick Leave Act. So that was subject to quarantine or isolation, advised to quarantine, or experiencing those symptoms. If in those situations, they get 100% of the regular pay for the 80 hours. Next slide, Brett. If it's an individual who is caring for an individual, or an employee who's going to be taking paid sick leave to care for an individual who's subject to quarantine, caring for a child who can't go to school, or their daycare provider, or the catch-all exception, then they're only entitled to 2/3 of the regular pay. In calculating your regular pay, I'm sorry, Brett, you can go to the next slide. In calculating your regular rate of pay, you will want to look at what the employee's average regular rate of pay was for each week that the employee has worked with the employer. You do take into account commissions, tip, piece rates. Those all go into the calculation. So one way of determining this is you can add up all the compensation that is part of the regular rate over the above period over that 6 months, and then divide that by the sum of all hours worked in that same period to determine what their regular rate of pay is. And then there are wage caps. So if you are taking the leave for your own use, so essentially quarantine, isolation, or due to medical symptoms, then the wages are capped at $511 per day, which is the equivalent to someone making approximately $132,000 a year over a 52-week period, up to $5,110 total. If the employee is taking leave to care for others or under the catch-all exception, then the pay is limited to $200 per day and up to $2,000 total per employee. Next slide. And a lot of people have asked us, well, how are we going to recoup this money that we're paying to our employees? And that's something that Brett will cover as far as the tax credits. But the last thing under the paid sick leave act before I turn this over to Brett, and then of course we will be taking all your questions after Brett finishes up his slides, is there are some exceptions for the Secretary of Labor. Secretary of Labor has the ability to exclude healthcare providers and emergency responders from the definition of employee. The purpose there is to keep essentially healthcare providers providing services and emergency responders out there to assist. And then the second exception is they may exempt small businesses from paying employees for the paid sick leave for taking care of their son or daughter while they miss school or are not able to go to their regular daycare provider, if such requirements would jeopardize the viability of the business. And in this case, you're looking at businesses that are 50 employees or less, generally speaking. Now, the criteria for this exception hasn't been announced yet, but the Department of Labor has said that it should be coming shortly. One last thing that's not in the slides is yesterday the Department of Labor did release the posters for employers to be putting up in their offices and in a conspicuous place throughout their premises. If you haven't received those and would like to, please let us know. We can make sure that you can get those. But now I will turn this over to Brett, and we will answer your questions as soon as he finishes.
Hello, my name is Brett Busacker. I'm an ERISA attorney in the firm's Boise office. I've been practicing about 20 years and just covering a lot of different issues that are coming up for employers as well as clients that I do work for that are providers and insurance carriers and so forth. So it's like a fire hose, to be honest. There's just so much coming at us, and we're doing to keep on top of it. And we understand that a lot of you are dealing with your businesses and everything that's going on. To have to accommodate these changes is a challenge. Obviously, everybody wants to take care of their employees, and so there's always the issue as well as, well, how are we going to pay for this, particularly if you're having shutdowns and business issues. At the same time, you're dealing with employees getting sick. So that's what I'm going to talk about at the beginning of the presentation, is just how is this going to get paid for, and then towards the end, I'm going to talk about some things that are going on in the healthcare world that are impacting employee benefit health plans, and then towards the very end, I'm going to just give you some just big pointers or tips of what goes on when companies are slowing down or shutting down or laying people off. Things that people should be looking at and paying attention to. So just to start off, I want to talk about the tax credits. The Families First Coronavirus Response Act provides an employer subsidy for providing this paid leave under the EFMLA and the Emergency Paid Sick Leave Act. So there's an expectation or an intent on the part of the government to provide dollar for dollar payment for the amounts that employers are required to pay in the form of emergency leave. The way the Act describes this is it's described as a refundable tax credit payable quarterly, and I think that struck the fear of heaven and earth on some employers because of cash flow issues. And so there's been some guidance since the Act was approved that explains that there are going to be ways that employers can recoup the cost of providing the emergency sick leave simultaneously or in near time to the time that they actually have to pay the leave. And that's what I'm going to talk with you about now. So what exactly will employers be entitled to be reimbursed for if they provide emergency leave, whether it's the EFMLA or the emergency sick leave? It's the same. And the reimbursements are intended to match what you've paid dollar for dollar. So that's the first thing that gets reimbursed. The next thing that will get reimbursed is the cost of providing health care to your employees who are on this qualifying leave. So the way you would calculate the amount of the credit or the reimbursement that you are entitled to as an employer is look at the cost of your health care for those people who are on the leave as a percentage or pro rata to the total cost of health care to provide to all of your employees, and that's how you would allocate the cost of health care towards this reimbursement or this tax credit. And then in addition to that, buried deep inside the Act, and I haven't seen anybody talking about this, but there is a reimbursement right for Medicare that's imposed on the emergency leave payments. The emergency leave payments are expressly excluded from Social Security, so you won't be withholding Social Security on them, but you will still be required to withhold Medicare. And so there's a gross up or a reimbursement for that as well. It remains to be seen whether this actually gets implemented or not, because some of the guidance that's come out from the IRS makes me think that there may be some adjustments in terms of whether these payments are subject to Medicare at all. But it's all moving very fast, and so that's just another thing to be tracking to make sure that you're getting reimbursed for any of the payments that are associated with this qualifying leave. So what's the process? Well, as I mentioned, the original rule and or statement in the Act says that you'll get reimbursed quarterly through tax credits, and that doesn't really work really well if you're paying the leave and then you have to wait 3 months to get reimbursed. So the guidance that's come out recently, and it's really informal guidance. They're supposed to publish regs this week or formal guidance, and so all we're operating right now is just an announcement that the IRS published late on Friday last week. And essentially what they've done is they've said, calculate the amount of the Social Security from the employer and the employee's perspective. So the Social Security that the employer would pay, the Social Security withheld from the employee, the Medicare for the employer and employee, and the federal income tax that's been withheld on employee wages for a payroll period. And that amount of money is the dollars that you would otherwise have to deposit as a federal tax deposit. And that amount of money is the amount that you can use to offset the amount of emergency leave that you've paid for that same tax period. So if you've paid $100,000 of emergency leave and you've collected $50,000 of payroll tax deposits, you're still short. And so there's a process for getting that deficiency or that delta, and you can request that from the Treasury, and they agree to pay it within 2 weeks. But if you've collected more from Social Security, Medicare, and federal income tax than what you've paid in emergency leave, you still have an obligation to make that additional federal tax deposit in excess of the leave on a timely basis. Okay. So how do you claim the credits? We don't really know yet. So you've taken your tax deposits and you've offset your emergency leave with the tax deposits, but the tax deposits aren't sufficient, and you still have some excess amount of leave that you've paid, you are able to request that. And what we don't know yet is what the timing and the frequency of that request will be. Will that be immediately after the end of the payroll? Will it be monthly? Will it be quarterly? We're supposed to get guidance on that. But what the IRS has said is that you can file the request, and within 2 weeks of the request, they will send you a check for the amount of the excess leave that you've paid. Couple things to keep in mind with respect to the credits. The credits are taxable. So if you receive credits, they will be included in the employer's income and treated as taxable income. And you do not get a deduction if you take a credit, if you receive the credit as well. So in other words, if you've paid these wages in the form of emergency leave, they're not deductible as wage expense because you've received the tax credit. Employers will be able to make a decision as to whether they want to take the deduction or receive the tax credits. And we don't know what the timing for that election will be or whether that election could be revoked or reversed later on. But we anticipate that there will be some flexibility around making adjustments. If you've taken credits and you decide you want to take the deduction, we presume you're going to be able to reverse that or to later take credits if you didn't do it initially. So that's all up in the air at this point, and we expect to receive guidance pretty soon. All right, so that ends the tax credits piece of what I want to talk about, and I'm going to transition now to the impact of COVID-19 on healthcare plans. So early on, several weeks ago, it's probably 2.5 weeks ago, the IRS published Notice 2020-15. And 2020-15 is directed for employers to sponsor high deductible health plans, and it protects employees who have HSAs from losing or having their HSAs disqualified because the employer is providing COVID-19 testing or COVID-19 treatment without satisfying the high deductible health plan's deductible requirement. So in other words, if your plan is amended or modified to provide COVID-19 testing, your health plan, or you're providing COVID-19 treatment, and you're in a high deductible health plan, that will not disqualify your HSA. The notice does not create a mandate to provide testing or treatment. It just alleviates the disqualification of the HSA if you have a high deductible health plan and you are providing these benefits without cost sharing. Okay, so then we have the FFCRA, the Family First Coronavirus Response Act, which came out last Wednesday. And that actually does create a mandate, a requirement that all group health plans and all carriers that offer group health coverage or individual coverage provide COVID-19 testing with zero cost sharing. Okay, so this is a law that's implemented under the Public Health Services Act, which was an act that was largely came into existence around as a result of the Affordable Care Act. So if you think of mental health parity and some of these rules that came out in connection with the Affordable Care Act, this requirement, it fits within that type of benefit that plans under ERISA and plans under the Public Health Services Act are required to provide. It applies to insured and self-insured plans, individual coverage, grandfathered plans. It does not apply to federal plans, but federal plans have a different requirement that's generally applicable as well. It also doesn't apply to things like limited scope dental, limited scope vision, or other HIPAA accepted benefits. So if you have some type of program that doesn't constitute broad-based group health coverage, but maybe is limited scope dental or limited scope vision, those insurance coverages are not subject to the requirement to offer COVID-19 testing. But any group health plan, any employer group health plan, self-insured or fully insured, will be subject to this requirement. The coverage for the COVID-19 testing relates to emergency room visits, urgent care visits, office visits, or telemedicine visits. And the amount of the zero cost sharing coverage that has to be provided to your employees or participants is the facility charge associated with the visit, the cost of diagnosing the need for the test, the actual administration of the test, and the equipment used in the diagnosis and the administration of the test. And one of the things that we've been advising folks on in a lot of this is if you've got a runny nose, if you've got a sore throat, if you're coughing, you've got blurry vision, if you have health issues, then whether it's looking at this from the perspective of the notice and the impact on the HSA or with respect to providing this coverage, we do think that the government is going to err on the side of flexibility so that individuals feel comfortable that they'll receive coverage for these visits if they are feeling unwell. Okay. So just jumping into some just general plan administration stuff, and I'm going to pick up the pace because I think I'm taking up close to my time. Keep in mind that when you're making changes to your health plan to comply with these requirements, there still is probably, in most cases, an amendment requirement. So keep in mind that you need to communicate with your participants. You may need to amend your plan. You don't have time to comply with all of the notice periods, like the SBCs, the Summary of Benefits and Coverage, generally requires a 60-day lead time before you make changes to certain types of benefits. Obviously, we're not going to be able to comply with all those requirements, but you should do your best to provide notice and information to your participants about their rights to receive these benefits under your health plans. Another issue that's come up is dealing with reduced hours. There's provisions in most plans, whether they're fully insured or self-insured, that says an individual regularly expected to work 30 hours a week. There's a lot of employers asking questions about people that are going home and not working, or who are reduced hours and dropping below the hours requirement. Our recommendation in most cases is that there's an expectation that you work 30 hours. Intermittent and temporary reductions in hours should not cause somebody to lose coverage in most cases. But you should definitely communicate and coordinate with your insurance carrier if you have an insured plan, or with your stop-loss carrier if you have a self-insured plan. Similarly, dealing with furloughs and leaves of absence and terminations of employment. In the healthcare space and the benefit space, it's always important to just be consistent with whatever you do. So if you're treating somebody as having terminated for purposes of unemployment or terminated of receiving a distribution from their 401k plan, you should be treating them similarly under their health plans. And the last few things I want to talk about is on the retirement plan side. Remember that when you have a 401k plan and you're sponsoring that plan and you have significant layoffs or reductions in force, and that's generally 20% or more of your participants in your plan, the plan does have provisions that requires immediate vesting of match and employer contributions for those individuals who are laid off in that context. So pay attention to that requirement as well. And again, coordinate your retirement plan and your health plan benefits, and pay attention to any notices that you have to provide if you're going to suspend a match or a employer contribution. And I recommend that you have conversations as a benefits committee, if you're a plan fiduciary on a 401k committee, to discuss with your financial advisors any issues with any of the investments, particularly any kind of fixed income investment that's tied heavily to the cash drawdowns that are going on in the economy. And that covers my piece. So I guess we're going to switch now to questions. Is that right?
Well, this is Tyson. I'll give a quick update on the CARES Act.
Okay.
We won't go into many details on that. We're working on providing an analysis and getting that out. But those of you that aren't aware, the CARES Act passed yesterday, late last night, I believe it was, and then it will be voted on by the House of Representatives on Friday, is what the current plan is. So that will have a lot of new and interesting pieces that I'm sure will apply to many of our clients, and we will provide you an update as soon as we possibly can. And this is Tyson again. I wrote down a couple of the questions that I've been seeing coming in from some people. So I'll kind of handle one, then pass it off to Matt and Brett, see if they have any others they want to address. One of them someone asked, how do you validate if someone is taking sick leave for self versus care for someone else? And one thing we have a few clients doing, and it's probably a wise choice for documentation purposes, is they're creating forms, kind of a little, I'm requesting leave, here's the reason why I'm requesting leave. That way you're getting notice from the employee that they're taking leave and the reasons for it, so you can determine and calculate their rate of pay. So that's what we would recommend. And if you have any questions or need any help drafting one of those forms, please let us know and we can help you through that. I'll take the next question again, I guess, unless Matt or Brett have anything they want to jump in on. Under the Act, what takes precedent to look at their family, the emergency FMLA or the paid sick leave, or can an employee do both? And the way these were drafted essentially is, as Matt explained, under the emergency FMLA, you don't get paid that first 10 days. However, you do get, this paid sick leave. And so if you are missing work as a result of having to stay home and take care of your child and can't telework, then you will be able to use your paid sick leave for that first 10 days, those first, 80 hours for their roughly 10 days in your employment. And then after that, you'll be getting the pay from the emergency FMLA. And so that's how those two are, it's anticipated those are how they're going to correlate and work together. Maybe some other areas where they may cross over, but where the emergency FMLA is so limited as to where it applies, we probably won't see too much of a crossover.
So this is Matt joining back in for the questions. I think that Tyson's spot on, and Tyson and I were talking earlier today. A lot of these questions that I'm seeing are really good questions, but one of the bits of advice I think we have right now, without further guidance, is that if we've got questions, look at your question and answer it, or prepare to answer it in a way that the government or the administrative body would answer your question in favor of the employee. That's a good way to start. Unless we've got clear direction otherwise, that's a good way to start. So I've got another question here that says schools closed on 3/15 and we have employees already taking time off with PTO. To count the 10 days they have taken prior to 4-1 and then permit the FFCRA pay immediately. I don't believe that's the case. The time off for the new amended family FMLA begins on April 1st. So I don't think you're going to count the 10 days beforehand. I don't believe that the act has been implemented. There's nothing in the act that says that it's retroactive. So I don't believe that that would be the way to go. I think they would get 10 days unpaid, and then if they still have PTO, they could take that, or if they're qualified for sick leave, they would get it then, and then you would go forward. Are you on board with that, Tyson?
Yeah, this is Tyson. I'll jump in on that too. There is no retroactivity to this act. So if employees have already been taking PTO for things, we don't go back and say, oh, here, we're going to pay you for this. This is 80 hours starting April 1st. And the other piece of clarification I want to provide for these 80 hours is the Department of Labor has come out and made very clear that employers cannot require their employees to use other, paid sick leave or PTO they've been given as general employees. In place of this, they have to give them these full 80 hours on top of what they already have. And so,
just saw a question pop up about PERS. We know if these are subject to PERS. I believe that we're subject to all of our normal withholdings except for the tax withholdings that Brett talked about. Brett, do you have any impact or any thought on that? If they're subject to PERS?
I do think that there's a question, and I don't have a specific answer, but I do think there's a question as to whether your definition of compensation plan would include this additional leave. So I don't know specifically about PERS, but that is certainly a question as to whether that would be included in determining comp under any benefit program. And a lot of it just comes down to the definition of compensation.
And hopefully we get some of that in some of our regulations that we just don't have right yet.
Yeah, and PERS is one thing, and that's statutory, but that's just as a general matter for all employers. That's something to look at with respect to your benefit plans, whether it's life insurance or 401k or employer match or whatever. Just we need to work through that issue, and it's really going to come down to the definition of comp.
Yeah. Okay, next, we got a question that says, is the countdown on April 1st, or is this an average of the year? Again, this is, and we're talking about seasonal employees. I'm assuming we're talking about to see if we have 500 employees or not. My understanding of the 500 employee requirement is that you count on the day that the person is requesting leave. And if you've got 500 employees, then you qualify or you're subject. Or you have less than 500 employees, then you're subject. If you do not have the 500 employees, then you're not. Is that your understanding also, Tyson?
Right. Yeah, it is. Yep.
Okay. The shelter-in-place order question. Do state and local shelter-in-place orders satisfy subject to federal, state, or local quarantine or isolation order related to COVID-19? This is a really, really good question. There's been some debate. So I think it's important to recognize the language that comes before that. And I'm going to read you the language that comes before that. Because we can't read it out of, we can't read it separate from it. So I gotta find it really quick. Hold on.
While Matt's looking that up, I'll answer a question that just popped up a few seconds ago. Is it 80 hours or up to 80 hours? If an employee became sick prior to April 1st and are still sick on April 1st, are they then entitled to 80 hours paid on April 1st? So in that case, the 80 hours starts to run on April 1st. So if they're sick up from now until April 1st, and then they're sick for one of these qualifying reasons, COVID-related reasons, for the next 2 weeks after that or whatever it may be, then they would still get the 80 hours, assuming they're a full-time employee that's entitled to the up to 80 hours. So hopefully that answers your question. And Matt, did you
Okay.
find what you were looking for?
Yeah, so back to their question. So the important language here is this. The statute says an employer shall provide to each employee employed by the employer paid sick time to the extent that the employee is unable to work or telework due to a need for leave because, and then we got the federal quarantine. So then the question becomes twofold. If you are in an essential position field where you're still allowed to work, then the quarantine does not impact you because you're allowed to work, so you're able to work. So just because the government said, hey, we have a shelter-in-place order going on, you are still able to work because you work in a essential field. If you are in a non-essential field, that's the big question, because it says the employee is subject to federal, state, or local quarantine isolation order related to COVID-19. The question is, and this is where we don't have any guidance yet, if you are unable to work because the employer has been shut down by the government, is the employee then subject to the order, and is it the employees being subject to it that is making you unable to work, or is it the employer who's subject to it that makes you unable to work? In other words, could the employee go out and get another job somewhere? We don't know. Again, this is the time where we say it's probably best to read that in favor of the employer, or sorry, in the employee. In which case, if you've been shut down or an employer's been shut down and you cannot operate due to COVID-19 and you want to avoid having to pay people sick time, you want to talk to your attorney about possibly laying everybody off who's not going to be coming into work while you're shut down. Because what you don't want to have happen is on April 1st getting 25 requests for paid sick time and you saying, no, you don't get that because we're shut down, and then them going to their local administrative body and an order coming against you saying, yeah, you got to pay them 80 hours, even though they weren't working for you and you had no business coming through the door. So you got to figure that part out. Hopefully, again, we get some guidance on this. Although I would not be surprised if we don't, and they leave it to a judge to decide how that's supposed to be interpreted. In which case, you would get multiple variations from different judges across the country.
And to that, Matt, another similar question that we've been asked, and I think I've seen kind of a version of it on the Q&As that have popped up is, if you have an employee who has been furloughed or had their hours reduced, do they still qualify? If they were a first full-time employee, then they get furloughed or the hours reduced, are they still entitled to up to the 80 hours, or are they analyzed as a part-time employee? Under a strict reading of the statute, I think we could make some sort of argument as attorneys that they would only be entitled to pay as a part-time employee because they're not scheduled to work at this current time, and we're going off the hours what they are when they requested the leave due to being sick or to take care of others. However, again, like Matt said, we have to assume that the Department of Labor is going to interpret these provisions in favor of the employee. And so if you are faced with that sort of circumstance, give us a call, let us walk through that with you, analyze a few different factors, try and come up with what the best route is for you. But that is one area of risk because of the ambiguity in the statute.
This is Brad. There is a question about withholding and setting up withholding. The statute or the act does state that these wages, the emergency leave wages, will be subject to Medicare, but not Social Security. And there isn't really anything in the act that excludes them from federal income tax withholding. So unless there's some additional guidance from the IRS on that, I would assume that they are subject to federal income tax withholding as well.
There's another question about. Well, go ahead, Tyson.
Oh, sorry, Matt. Another question we have is, what sort of certification is required for an employee who's saying they're staying at home? And I think and we kind of discussed this earlier about a form that the employee can, check and say, this is what I'm staying home for and this. the question sounds more like it's asking almost like an ADA sort of certification, some sort of doctor's note. The Department of Labor and a number of government agencies across the country have come out and been trying to advise employers not to seek these sort of doctor's notes because of the fact that all our medical services and medical providers are so overwhelmed right now. Again, that's, your preference if you want to do that, but that's where the guidance is. And so we think a form where at least we can hold an employee accountable saying, you told us you missed for this reason. And if it comes out to be a lie, we can, use that as a basis for some sort of discipline or termination. But at this point, the government generally wants us to avoid bombarding the doctors with all these notes of, this person needs to miss work for this or this issue, or they have this disability. So be mindful of that. Again, if you have any questions, give us a call.
Another question is, what if a person, already used a bunch of their FMLA leave and then they're let go before April 1st? Are they still entitled to these benefits? I mean, if they're let go before the benefits take into effect, I think the general answer is no. If a person is laid off or discharged before April 1st, they're not allowed to get the benefits, which is what a lot of my clients are doing. They're letting people go before him because they're concerned about the impact this is all going to have on them. When will the DOL be issuing criteria for excluded healthcare providers? We have no idea. That's a great question, and we just don't know. And I wish we could tell you, but we're not the DOL, so we can't say.
I believe we've covered most of the questions. If anyone has anything that's really urgent that they that we haven't answered, that we happen to have missed, feel free to jump it in real quick, and we can see if we can get to it.
One question here says, I thought employee was eligible if they worked in the last 30 days, regardless if you laid them off. So if they're laid off before, if they're discharged before April 1st, then this doesn't apply to anyone because before the act goes through. If we're discharged after April 1st and they've already requested the leave, you could be looking at some problems because maybe when they're discharged, they're going to say that we're discharged because they asked for the leave. And the employer is going to be forced to show that it wasn't a retaliatory discharge, it was a business necessity discharge. I do not believe that the sick leave or the FMLA Act is intended to apply to former employees in any way. Tyson, any thought there or disagreement?
No. One other question I saw was on notices about, how we have to handle those. And again, for the most part, you will handle the notice of the Department of Labor put that in a conspicuous place out in your premises. For those employees that work outside the office and that don't come in, the Department of Labor has clarified that you may satisfy your requirements by emailing or direct mailing the notice to the employees or posting it on an internal or external website that the employees have access to. But that should, at least cover all the notice as far as giving the employees what information they need.
I think from reading a lot of the questions, the general fear and concern is these employees, how do we know that they're being honest? Because it makes it so easy for them to take time off and get paid. And employees will do that if they're capable. And to be perfectly honest, there's just not an answer for that. You can certainly say we're required a doctor's note, but like Tyson said, the DOL is asking that we don't overwhelm the healthcare facilities with doctor's notes because people are homesick. And someone can simply say, oh, I've got a dry cough, so I think I'm going to stay at home. And that seems to qualify. So the administrative agencies are going to say, well, you shouldn't be concerned about it because this money is going to get paid back to you from the federal government. anytime that the federal government is required to do something on time or to benefit us, there's a fear because there's no way of knowing if it's actually going to happen. So I think these are reasonable fears and concerns, and we just don't have solid answers at the time because they haven't been given to us. These are questions I think are good to write out and look for. Give us a call if you want to try and work through them, or talk to your own counsel and try and work through them. Analyze it as best you can. Try and consider what a reasonable or a maybe normal judge would do, considering the facts and circumstances, and see what course of action is best to take. And that's really all we can do. I saw an article that said that something like 3.5 million people applied for unemployment yesterday. It's a record number of unemployment applications, and I think this is going to get bigger and worse because there's fears associated with not just COVID-19, but also with these statutes and how they're going to impact the company. So the best thing we can do is say right now, without any guidance from the DOL, is get with your counsel and talk and try and plan for all different scenarios, and then just take the best course you can take. Any other thoughts before we wrap up, guys?
Nope, I don't have anything.
Nope. Not for me.
Okay, well,
one thing I will emphasize is we do have. Sorry, Matt. I didn't mean to speak over you. I was going to say I do want to emphasize we have a strong team. A lot of attorneys have spent a significant amount of time over the last week or two coming up to speed on everything. So if you have any questions, please reach out to us. If you reach out to someone who can't get you the answer, we'll find someone who can. So just give us a call. Let us know if you have any questions, and we just wanted everyone to know that we're here to help you. And everybody stay safe.
Great advice. Thanks, everybody.
Thank you.